So does a continuous appropriation violate the principle that one legislature cannot bind a future one? According to the California Senate Budget and Fiscal Review Committee, a continuous appropriation is defined as the amount available each year under a permanent constitutional or statutory expenditure authorization. And a continuous appropriation is not dependent on passage of the budget. Similarly, the California Department of Finance glossary of terms includes two definitions of the term continuous appropriation. The first definition is an appropriation for a set amount that's available for more than 1 year. The second definition is a constitutional or statutory expenditure authorization that is renewed each year without further legislative action. The amount available may be a specific recurring sum each year, all or a specified portion of the proceeds of specified revenues that have been dedicated permanently to a continuing and certain purpose, or whatever amount is designated for the purpose as determined by a formula, for example, school apportionments. Now, note Government Code Section 13340 sunsets statutory continuous appropriations on June 30th, with exceptions specified in that section and some other statutes. And Control Section 30.00 of the Annual Budget Act traditionally extends the continuous appropriations for one additional fiscal year. Now, at the same time, there's a judicial doctrine at the federal and state levels that one legislative body cannot limit or restrict its own power or that of subsequent legislatures, and therefore the act of one legislature does not bind its successors. Because a continuous appropriation does not require further legislative action and will continue into the future, at least by definition, does a continuous appropriation violate this judicial doctrine of binding a future legislature? The point of a continuous appropriation, of course, is to provide a specified sum of state funds on a continuous basis without the need to go through the annual budget process. These can be authorized by federal law, the state constitution, or a state statute. As a California appellate court noted, in some circumstances, the law authorizes continuing appropriations that run from year to year without the need for further authorization. This was noted by the California Supreme Court in 2003 in White v. Davis. A court of appeal also initially scrutinized this category of continuing appropriations. The appellate court decision was issued in 1994 in California Association for Safety Education versus Brown. And in that case, the Court of Appeal explained that an appropriation is a legislative act setting aside a certain sum of money for a specified object in such manner that the executive officers are authorized to use the money and no more for such specified purpose. And a continuous appropriation runs from year to year without the need for further authorization in the Budget Act. Now, we have in California a number of statutes as well as voter-approved measures that establish continuing appropriations that are independent of the Annual Budget Act, which authorizes payments for items such as tax refunds, disability and retirement payments, payments to bondholders, and other provisions. In explaining continuous appropriations, another court of appeal in the White v. Davis case said, nothing in Article 4, Section 12 expressly bars continuing appropriations. On its face, Section 12 prohibits the legislature from sending specified appropriations bills to the governor prior to the enactment of a budget, and it provides for exceptions to this prohibition, but it does not otherwise limit the legislature's authority to enact appropriations. So there is this provision that limits the form in which an appropriation may be adopted. So what exactly is the issue being raised? Well, there's the familiar principle of law that no legislative board by normal legislative enactment may divest itself or future boards of the power to enact legislation within its competence. This was the California Supreme Court speaking in City and County of San Francisco versus Cooper in 1975. And the California courts have ruled that neither house of the legislature may bind its own hands or those of future legislatures by adopting rules that are not capable of being changed. That was also the decision of the Cal Supreme Court in the case of In re Colli. Because a continuous appropriation would bind a future legislature to continue the specified annual funding level, it would appear that such an appropriation violates the judicial doctrine against binding future legislatures. Nonetheless, the reality is that absent a federal funding requirement or a state constitutional requirement, any continuous appropriation made by statute can in fact be changed by a future legislature. As a result, even though a statutory continuous appropriation may violate this judicial doctrine, in practice, such a continuous appropriation can simply be changed or extended by another enacted statute by the same or a future legislature.